Recent High Court ruling on GST return mismatch cases. The Goods and Service Tax (GST) Act was inaugurated at midnight on July 8, 2017. This legislation's primary objective is to provide a framework for imposing and collecting taxes on the intrastate supply of goods or services, or both, by the central government and related matters. Under the GST Act of 2017, 13 distinct types of returns must be submitted, including GSTR 1, GSTR 3B, GSTR 5A, GSTR 6, GSTR 7, GSTR 4, GSTR 5, GSTR 9, GSTR 10, GSTR 11, GSTR 8, CMP 08, and ITC 04. However, not all returns apply to every taxpayer. A mismatch refers to a situation where two elements or values fail to harmonize or correspond with each other. GST return mismatches problem can occur in various ways. Each of the returns submitted by taxpayers is interconnected both among themselves and with the data provided by the GSTINs mentioned in them. Consequently, when comparing the data received from one taxpayer with that from the counterparty, they should align. Any discrepancies between these data sets are referred to as mismatches. Calcutta HC, GSTR 2 and 3B mismatch case. BW Suncraft Energy Pvt Ltd and Assistant Commissioner. The High Court of Calcutta has ruled that buyers who adhere to the conditions specified in Section 16(2) of the Central Goods and Services Tax (CGST) Act and State Goods and Services Tax (GST) Act of 2017 are entitled to claim input tax credit (ITC) and are not responsible for discrepancies in the goods and services tax return GSTR 2 and GSTR 3B due to the seller's default. Consequently, the appeal is granted, and the orders made in the writ petition and the order issued by the Assistant Commissioner of State Tax are overturned. The court directs that action should first be taken against the seller before any action can be commenced against the appellant. Delhi HC Buyer GST ITC Denial Case. BW Bharti Telemedia Ltd and Union of India. The Delhi High Court is scheduled to hear a series of petitions jointly addressing the denial of goods and service tax (GST) input tax credit (ITC) to buyers on the grounds of default by the seller. The petitioners have challenged the validity of Section 16(2)(c) of the Central Goods and Services Tax Act 2017. The bench observed that the restriction imposed by Section 16(2)(c) regarding ITC is analogous to the condition outlined in Section 9(2)(g) of the Delhi Value Added Tax Act 2004, which was modified in the case of Quest Merchandising India Private Limited versus Government of NCT of Delhi for genuine purchases and affirmed by the Supreme Court. The court has scheduled the case for a joint hearing on 19 April, along with other pending petitions. This case is under the jurisdiction of Justice Rajiv Shakdhar and Justice Tara Vitasta Ganju.